fast, and for many, uncomfortably fast. In just under 2 years, Parliament has passed or proposed some of the most consequential and contested laws in recent memory, from the reintroduction of military trials for civilians despite a Supreme Court ruling, to new bills that are framed around sovereignty as well as security. A pattern is actually emerging. Is the Parliament asserting authority in the name of national stability, or one reshaping the rules of engagement? And this is between the state and its citizens. And at the same time, the post-election environment is also telling of its own story. Arrests, unresolved petitions, and the growing concern about the shrinking civic space. And so this morning we ask and unpack, are these laws actually protecting you, the Ugandan they say they are protecting, or they are redefining democracy for us as a country? Joining me to my immediate left is Cohen Champene, an MP-elect for Igara West, entering Parliament at a time of intense legislative momentum. Honorable, you're most welcome.
Thank you very much, our host on the NTV. As they have told you, my name is Cohen Amanya, and I'm MP-elect for Igara West. And at the same time, I'm a lawyer by profession. So, as you have said, we come in at a time when the country is going through a lot in terms of policy, in terms of legislation and expectation from the people. Ugandans expect a lot. Ugandans are expecting us to, of course, protect them. The government wants to protect them. So we are coming as, at the time when, as a country is going through a lot, and as the members of Parliament, we need to balance and put our legislations on what we call the equilibrium, or the balancing scale. So that if we are to legislate, what will be the perception out there, the international world, the community, where we live? It doesn't matter where you come from or the party you are in. Because at the end of the day, we have to make the rules for the country to protect this country called Uganda.
Okay, all
yes.
right. And this country being divided on only one party, and that is being a citizen of the country.
Yes.
The National Unity Platform Toro coordinator is also sitting with us on this discussion. Innocent Natkunda, representing opposition perspective, especially on governance and the civic freedoms. Good morning to you, and you're most welcome.
Good morning, Priscilla, and the viewers out there. It's a pleasure to be here.
Mm-hmm. Okay. Now, as we are setting the scene for this conversation, we are looking to the 12th Parliament that is yet to take its oath and start its order of the day. But we get to look at a Parliament currently that has actually passed at least 8 major laws in a short span, with more than in the pipeline, including the sovereignty bill that is yet to become an act in itself. Critics are saying that this is signaling consolidation of power. From where this gentleman is standing or seated this morning, is this legislative reproductivity that we are seeing right now, or are we actually seeing it as an overreach? I'll start with you, Cohen.
One thing that I think for me, I'm looking at the current legislation and what we call the sovereignty bill. You know, as we sit here as a country, there is what we call Article 1 of the Constitution, which talks about the sovereignty of, of Ugandans. And in legislation, there is what we call public participation. And in public participation is constitutional. You have to do it. The only difference we are seeing is where the key stakeholders are opposing the bill, which is part of the public participation anyway. But now the question is, will the Committee of Parliament take considerations for purposes of what the public has said? Because for purposes of making the law, and for Ugandans who are watching us, maybe who might not understand how the laws are made, is that we have the Parliament, when now the bill is brought to Parliament. There are 2 types of bills, where the bill is by the government or the private member's bill. Now, the Parliament sieves through whether the bill should go to the plenary or it should be debated by the entire House. Now, all that is about the debate. Then they call for public participation. They call for people to bring in their views. After that, it comes back for the second reading. Now, after the second reading, it is supposed to be debated on. Now, the Parliament passes it on the third reading. Then it goes to assent, that is for the signature of the President. The President has two roles. One, to sign it or bring it back to Parliament the way it is, or with amendments. Now, the President has guided, and I'm sure you have seen in the public, he's saying that this is not what I intended or what the bill intended to do. Can you amend? That puts the committee in another dilemma, because now you see there is an amendment to the bill. Once there is an amendment to the bill, then that can be looked as a new bill. So in all this, whatever the government is doing, will there be public participation? Will there be a consideration? Because the central bank or the Bank of Uganda is telling you this is wrong. So can we hear them? Will the president sign it? And as Ugandans, we need to look at this as one of the in our constitutional dispensation, that Uganda is following a constitution. Otherwise, we'll have the law that will come in and it is amended and the president signs it, and that's all.
On that note, are we seeing the Parliament more prioritizing of speed and volume versus actually intentional legislation for the longer term? When
I think the legislation, they are looking at the longer term. Maybe the timing is what everyone is having a problem with. But it doesn't mean that as a country, this bill is not a priority. But the question is, it's the timing. When you look at the laws, we have so many laws that can cater for this, for everything. Mm-hmm. But the question is, in terms of stability and security of this country, where are we? Can there be somewhere where, because we have seen foreign interferences in most of overthrowing the governments. So the government has to protect itself in terms of sovereignty. But the problem where Ugandans and where people are coming up are the contents. The bill itself is good. But the contents that are inside, maybe that's where people have a problem.
Okay.
Yes.
Taking it to Innocent from the opposition lenses, especially, not just on the protection of sovereignty bill, but on quite a number of bills that have actually mushroomed in the 11th Parliament. Are we looking at coordinated legislation that is having an agenda at shrinking the civic space and political space, or is it a series of discoordinated things, decisions reacting to political pressure?
Thank you, Madam Priscilla. First of all, I want to refer to the 1990s Australia politics, where we had the dog whistle politics, that the government can bring a bill or a law targeting specific individuals, but then blend it in a way that it is not so clear to be offensive to the public directly, and choose to pass it through other lanes. Many bills come in that line and find their way out, and the sovereignty bill is not so exceptional to that cause. Of course, Madam Priscilla and the viewers, there's also a strategy whereby government can bring the law into the public floating, so they discuss it and hear what the reactions are, and then blend it better and still make it pass. In the past few months, even before elections, we had in the corridors of Parliament, there is an upcoming law to allow Parliament to vote for the president. So, and that to me it falls under the trial balloon politics. That even after allowing it leak to the public domain, they have seen the loopholes in that, and now the way of sealing those loopholes to concretize the channel is to bring the sovereignty. Because according to my opinion, if they just brought it the way it was, it would mean that a foreign agency or a foreign country can pick interest in the politics of Uganda and sponsor one person or one party, and it takes lead in the country. But now, if you bring in the sovereignty bill, where you have restricted the funding because you need disclosure, and disclosure to the minister who is appointed by the current government. It means that this money that is coming to divert the interest of the government in power are managed at the ministry level, not to allow this money come into the house. Otherwise, given the nature of the parliament we have as a country, where a majority of our members of parliament are really political hawkers, and by the way, Priscilla, we had discussing the sovereignty bill, the contents and all that kind of thing. But there is a very, very comfortable member of parliament there who is not even bothered about what is happening in this bill, and is only waiting to see what is the price tag attached to this bill. So the sovereignty bill comes in to seal this gap, that it is only the government, it is only within the interest of the government of Uganda, that if we want to pass anything through parliament, taking advantage of these political hawkers who we have elected as members of parliament, we shall just bring it and give them money they sign. Not any other person else who should come to the house and give them money and maybe have it.
So that is
these
to
members
say,
of parliament have a price tag.
Maybe
that
point
is
of
to
clarification.
ask, before you clarify, if this is coordinated, then what do you believe is the end goal of strategy for the government?
Definitely, we're going to see ourselves transforming from a hybrid democracy, which is coupled with dictatorship, into a monarchy. That since the government in power has all the resources and access to it, now they will use the same resources to come and bribe most of these members of parliament who have a price tag, and then have their way out of having a monarchy, and the president is only determined by the people who are in the government in their own wish and own favor, which limits, because this sovereignty bill is entirely about managing opposition and civil society organizations. You have to disclose funding. After disclosing funding, the oversight role of this money you are getting in form of maybe donation or aid or anything to do an activity is fully managed and fully monitored by the Ministry of Internal Affairs. But also, there's an attachment of penalty if there is a breach in any of these activities. If, for instance, you said you're getting money to do maybe a charity organization and maybe you're paying fees for the orphans, if you ever divert any coin to anything political, the bill talks about up to 2 billion penalty.
Okay.
So this means that entirely the opposition has no space, entirely civil society organizations have no space, and we are only going to be vulnerable to only one party and probably a single government, which will dictate who should be the next president, who should sit where, and where should they get the money.
Go ahead. This is not the first time we are seeing this nature of control from the government, as people are perceiving it. When Parliament also did pass other laws, you get to look at an appearance of it having a contradiction with the Supreme Court.
I think, and this one I want to say this. You know, especially my colleague here from the National Unity Platform, let us not create the fear of an unknown. You know, he has talked about members of parliament being hawkers and all that and all that. What I want to say is, first of all, these are members of parliament that have been elected by the people. When we are talking about the democracy, as the opposition, they are here, they can talk, they can do what. But the only challenge that the government, I think, is having, and what my colleague is just saying, is that they want to curtail the funding. The question is not about funding, and he has just mentioned it, that what if you come, you bring in money for purposes of other political prayers and other things. And I wish they can take keen on the letter by the president and look at it. Secondly, we are having this bill. It is being debated. What is the position of opposition? Have they, for example, NUP, National Unity Platform itself, where he comes from, has it made a memorandum to Parliament over this issue? As a party, which is a concerned party. So let us not lie to the public here.
Okay.
Yes.
Moving away from that,
yes.
Looking to the law versus the people right now and
yes.
the rule of power, the sovereignty bill, it's still a bill, it's not yet an act.
Yes.
But there are others that have become an act that have really seen or brought into contradiction what the Supreme Court's position is. The UPDF Amendment Act has been passed, and it was really controversial, and begs the question, is the legislative independent in works over rulings such as those of the Supreme Court, especially you, who is one that follows the legal channels?
Thank you very much. I will begin by juxtaposing. For example, I will use 2 acts of parliament that have been declared, 3 acts of parliament that have been declared unconstitutional. One is the public order management. That one is still there with its provisions. You know how it was declared. We had what we call the court martial, the Baziguruka case in the Supreme Court. And this, we need to understand that we have 3 arms of the government. The 3 arms of the government, we have what we call separation of powers and independence of those institutions. But in separation of powers, you can't run away from accountability. And this is where the issue comes in. How do we measure accountability vis-a-vis the separation of powers? When you look at what the Supreme Court said in the matter for the court martial, it was very categorical that under the Constitution, there is no law that gives the mandate to the court martial and its procedure. It also faulted on how the chairpersons of that court are chosen. It gave the guidelines. What does the government do? Because these are some of the live issues that happen in a day-to-day life. We have people who have firearms. We have people who pretend to be army and rob people. So what the government does, brought the law. There was a lacuna, what we call the lacuna in the law. So if there is a lacuna in the law and the government resettles it, then it does not become a bad law. What the government ought to look at is the law vis-a-vis the people. What is the public outcry about this law? Some of the laws that are in this country, of course, people have issues against it. But to a certain extent, we need also to look at the bigger picture. What is the role of the government in trying to protect the people? Because at the end of the day, government has a single role of protecting Ugandans, including me, you, including opposition, it doesn't look at that. That is the same leeway when they are making the law. We need to look at everyone. We need to look at the opposition. We need to look at the government. We need to look at the common wananchi, the Wanjiku, the person who is out there. So that is why in what we call the law-making process, all the parties, the prayers must be looked at. And as the newly elected member of parliament, of course, I expect that let us be open to each other, let us criticize with each other, let us make the laws that will cater for all Ugandans. And also, the National Unity Platform, the opposition, the FDC, PPFF, the ANT, let them also create laws and put government to task. Because at the end of the day...
Unfortunately, they can't create the laws.
No.
They can only speak into the ones that are being created.
I can tell you what they can do
before Parliament.
I can tell you what they can do.
But in that space, you get to look at the rule of law, innocent, versus the rule of power. There's been increasing reports and especially pressure towards opposition through all of these arrests of political crackdowns, especially post-election. And we're talking about 2 election cycles here. So in your view, are these law enabling enforcement, or are they actually enabling suppression for you from where you are sitting?
Maybe, Patricia, can I mention something?
Let him speak.
Okay, fine.
Madam Priscilla, looking at the constitution we have in the country and what actually is at play, it is evident and very clear that what is written in most cases is not what is practiced or even what is brought to sanity of the population. He's talking about the constitution and the arms of government. They look so interesting when you look at them in the paperwork and also read about them. But if you're a student of real life politics in the country, real life governance in the country, you realize that most of the laws have nothing to do with what is actually happening in court. For instance, he knows that after 48 hours in cells, you're supposed to be tried. He knows that you're supposed to get a bail after some specific period of time. Where does it apply? Haven't we had Dr. Kizza Besigye and the rest of the political actors in jail for over a year without trial, without bail, without anything? But when you open the Constitution, these articles are very clear and they look so much caring for the people down there. And when they are being brought, you really say, ah, wow, this is a country we're going to have. But in actual sense, what is actually working in most of the institutions of this government and this country is not these laws, it is just a phone call. Someone has to consult what should be done, even at the judicial level, to decide, not what is written. And should you risk to do what is written, even in the Constitution, you risk your job. Many scholars and many lawyers, very good lawyers in this country, have failed to practice law simply because the laws we have are not applicable, are not practiced in centers of justice where they should be, because every institution is infiltrated and a lot of divergence is being caused, not because it is in line with the law, but because it is in the interest of the government and in the interest of those who want it to take that specific shape. I will refer to so many things, but of course, Madam Prisa and the viewers, you know that there are entities where it is hard, very, very hard for you to even speak referring to the law, just because the interest is in favor of the government. I'll for instance tell you, recently I've had a reshuffle at the UEDCL, and the engineer Jocelyn is appointed the acting MD now. But when you dig deep down, you realize that Jocelyn is a daughter to Ruakakoko, who is the former URA boss. This tells you what? That much as we have regulations and policies to say that we need this person for this specific position, you also need these contacts. You need to have someone who is referring you. I will talk about national order. When you are an MD in national order, you're supposed to serve 2 terms. We have an MD who is serving the 3rd term, and the replacement is not yet found. Maybe you could be waiting for the son or daughter to replace. I'm trying to bring this to drive my point home. That yes, laws exist, but connections, and I'm talking about state connection. How you connected to the state guarantees how many cases you will win in the court, guarantees how safe you will drive on the road with and without a permit, guarantees how many places you will access with or without security checking you.
So the law in itself is not giving you guarantee.
The law in Uganda is applied unfairly.
In that place, Innocent, how then would you have accountability be meaningful, especially within the 3 arms of government, to such concerns that you're raising?
Many debaters and analysts in this country and outside this country believe, and including myself, believe that Uganda does not have those laws. We are just being led by a dictator, and he can decide anything to do, whether it is lawful or unlawful, and putting the judiciary to account is a very, very huge mountain for them to climb. Even in the legislature, I'm just explaining to you that these members of parliament, most of them, they come to parliament to do business. So when you put them to account to this country, what they are doing in parliament and how is it relevant to the people, they have nothing to really bring on the table and justify. What brought them to parliament, the majority of them, is business. I can assure you that from where I come from, there are members of parliament who we knew that if a returning officer just made a mistake and announced a different person, we would see them corrupt. They mortgage everything they have acquired in life to enter parliament. And after being declared, it is enough. They just wait for 5 years to again elapse and come back to the people, brave their way back, or find a way of conniving with the electoral officials to have themselves declared. So if we have a parliament full of such a people who have nothing to account to the people who voted for them, who do not even have this country at heart, it means that we shall continue to see them as just an entity of government, as just an arm of government that has very less impact in the lives of people, apart from even these laws, by the way, if you realize, Like I said, you go to parliament, interview them. There are many parliamentarians who do not know the contents of this bill, the intent of this bill, and the repercussions it can have on them and the other people in the country.
We turn to Cohen, impact and accountability, especially in terms of human rights, impact assessment. Is this part of the legislative process, or are we continuing to see it only coming into focus at the point of criticism?
Thank you very much. I like what my colleague wants to portray and put outside there. In terms of human rights, in terms of the rule of law, the way you have said, we all have rights. And there's something that I wanted to clarify what he just said. It's not true that you need to know someone in the government for you to get these jobs. Some of these jobs you qualify. You talked about the national water, the MD. And I'm sure in your home area, you know that the service delivery of national water is at your doorstep. So when you see when you look at the opposition, they always want to portray that, yes, he has put two yardsticks, electricity and water. They have water. Now, when there is an issue in the electricity sector, they are like, oh, why have you changed? When there is no issue in water, they are saying, why haven't you changed? Let me just say this. The law allows the fountain of honor to make appointments. That's number one. Secondly, you talked about human rights.
The law allows the fountain of honor to make appointments,
yes,
but the law does not allow the fountain of honor to go outside the law itself to keep
and that's where I'm heading. That's where I'm heading. The law allows, for example, that the president has not appointed the UEDCR ED in the acting capacity. The person is in the acting capacity. The other person has gone, has been sacked, has been suspended. So it is prudent that within the law, there has to be someone in the acting capacity for purposes of doing certain works. But you see, when things happen that way, the opposition does not want these things to happen. He talks about the law. And let me justify. He talks about that the court, you know the court. When National Unity Platform had an issue on the registration of their political party, where did they run to? They went to the court. Chibarama had the case. You won the case. How come when now that case was being had, why didn't you blame the court that it gave you the judgment? If the government had an interest in stopping NUP to be formed, it would have interfered. But that one, when now it favors them, they don't want to talk about it. Let us also know that the courts can work independently. And the judiciary has worked so. You see, the challenge that we always have, if a dead case is dead, it's dead. It's dead on arrival.
Okay. On that note, as we're coming to the close of this conversation, in one sentence from both of you, what would be the single biggest risk in Uganda's current legislative direction, and what must change? Let me start with you, Innocent.
Thank you, Madam Priscilla. One thing that I must come out openly to say that should change or must change in this country is that if we could have leadership, especially at the top, I'm talking about the presidency, because you realize that most of what we are suffering is coming from State House, and the rotting goes down the hierarchy. That's how we have seen the judiciary die, the legislature die, and all other arms of government. If we could have a way of having another president elected and put all this kind of mess to order, we would have a better country. Madam Priscilla, we did not mention that we have just come from elections. And these laws are being made to divert us from the militarization that was in the election, the brutalization that was in the election, the dehumanization that was in the election, and now, boom, they bring the sovereignty bill and other bills that are related. This is what Boris Johnson referred to as a dead cat strategy. That amidst a hot conversation, amidst a very, very key issue in the community, or on a round table, you boom, bring a dead cat and throw it on the table. People get diverted from what they are discussing and focus on the dead cat, focus on the stinking and other things, forgetting the main issue they would have been discussing. As we're nearing the swearing in of the president and all other members of parliament, including him, we would now be discussing the legitimacy of the elections we have had and the unfairness that everyone saw. and how can we better these elections in the coming future.
Okay.
But because we are now embracing the dead cat strategy into the politics of Uganda, we are just throwing the dead cat on the table of Ugandans to divert them from the mind of thinking about the just concluded chaotic elections to now the sovereignty bill that has no future and end for Ugandans. Thank you so much
for your contribution.
Thank you, Innocent. And I mean, Uganda has just held peaceful elections. We have voted overwhelmingly to the President of the Republic of Uganda. Now, for me, what I would suggest to my colleague is that next week, let us all come and embrace on how the new government should come into place. That's number one. Secondly, as you have just, and you have just juxtaposed that we have just come from the elections, we have seen the prayers both from opposition, the government, people vying. That is democracy. Democracy in Africa and the whole world, it comes with a pain. There are those who jubilate and there are those who don't. If you win, you are okay. If you lose, then democracy is bad. And that's why I'm saying that arms of the government, the three arms of the government, let them work independently, the way they are working, let the opposition do their work. Also, in terms of putting the government to hold and also do what they're supposed to do. And you asked me, there is something that I wanted to say. Lord Denning, as I wind up, he was a well-celebrated judge now. But in the years of his, when he was a judge, Lord Denning used to be a dissenting judge. What he made and what he said as a dissenting I mean, if you have three judges, as I round up, if you have three judges, the two can say, demolish this building. Lord Denning would say, don't demolish. The time has come to pass. Whatever he said in the dissenting now is the law. It's the right time for opposition to bring in what they feel is the minority bill for purposes of posterity. Maybe there are people like us who might resonate with you and agree with you and then accept. We have to live in this government, in a peaceful country like Uganda, and that's why you can come to this television and say whatever you want to say against the government, and you go back home. There was a time when you would not do that in Uganda.
MP-elect about to swear in for the 12th Parliament and Innocent. Today's conversations do underscore critical tension at the heart of our democracy, the balance between authority and accountability, laws not just being instruments of governance, but also signaling intent. When you do have laws increasingly tilting towards security, sovereignty and speed, the question becomes not just what is being protected, but also what is being constrained in tandem. So as the new parliament is taking shape, the test will not only be on how many laws that they can be able to pass, but whether they can actually expand the trust of the people, uphold the rights of the people, and also strengthen the institutions that then serve the people, because ultimately